All right, good afternoon, everybody. Welcome. My name is Andrew Schaefer from Trafalgar. I'm based in Trafalgar's Johannesburg office. I'd like to introduce and welcome our distinguished guest this evening, Jennifer Paddock. Jennifer, welcome. Thank you for joining us. I'll introduce you more fully shortly. And Karine Kutsia, my colleague from Cape Town, who will be helping us with an introduction as well. So just to introduce Jennifer more formally and more fully, and quoting from the Paddock site, Jennifer is the distinguished daughter of Professor Graham Paddock, that many of you might know as a doyen of the sectional title industry in South Africa, one of the architects of the legislation that's applicable to community schemes. Jennifer studied law at UCT, and she worked with her dad, Professor Paddock, doing articles, and she's completed a number of specialist sectional title courses, law at work, as well as a short and advanced course in sectional title schemes. She's also developed a lot of the training material that Paddock's offer to managing agents, to trustees, to HOA directors as well. Jennifer's also worked as a managing agent in Australia, and fortunately decided to come back to South Africa and to focus her skills and interests here in our marketplace. So I think you, Jennifer, we're very grateful you're with us tonight, and certainly by the strong response we've had to this topic, it's going to be great to have your input on the, often thorny topic and somewhat confusing topic of exclusive use areas in sectional title. We're going to try and get through the discussion in about 30 to 40 minutes, and then there'll be time for questions. Karine and I have had a whole number of questions coming in over the last 2 days, so we'll try and bring those into the discussion. Karine and I will answer any questions that come on the Q&A, and if there's any repeat questions, we'll bring those up for discussion just to check for clarity and understanding as well. We'll close at 6, and there'll be a short survey. If you have time, 30 seconds, just to give some comment on how you experienced the webinar, any suggestions for next time, any topics you'd like us to cover going forward. We're planning on offering webinars in September and October, and then going into recess for the end of the year, and taking a break probably until March next year. So let's continue. Karine, can I hand over to you just to give us a brief overview of the applicable legislation and some legislative concepts before we hand over to Jennifer to continue. So thanks very much.
Thank you, Andrew. I want to start with the bad news. So the bad news is that exclusive use rights are exclusive to sectional title schemes. So unfortunately, tonight we will not be speaking about homeowners associations, share block schemes, any of that. So yeah, exclusive to sectional title schemes, but it is a very relevant topic for sectional title schemes. So that's why we're covering it tonight. And then just if we look at the definition of an exclusive use area, it means a part or parts of the common property for the exclusive use by owner or owners of one or more section. So I made a note there at the bottom just to tell you a funny story. I had a huge fight a while back with an owner in Cape Town and her attorney that she wanted to have exclusive use rights over her loft. The loft inside the section, already part of the floor area, but she was adamant, and her attorney was adamant, that they wanted her to have exclusive use rights over the loft. So yeah, exclusive use only over parts of common property. Your loft inside your section, already yours, you don't need exclusive use on it. So that was just funny for me. Then we had a question or a couple of questions with regards to selling exclusive use areas. Jennifer will definitely be dealing with those as well. So I just wanted to highlight at the beginning, there's a couple of types of exclusive use areas. You get exclusive use areas in terms of the plans, you get exclusive use areas in terms of the management rules, you get exclusive use areas in terms of the conduct rules. But it is only exclusive use in terms of the plans that are registered real rights and that can be sold. But yeah, Jennifer will be speaking about that further as well. So it is my pleasure to hand over to Jennifer.
Thank you so much for the warm welcome, Andrew, and thank you, Karine, for introducing the topic. I'm very honored to be here today, so thank you to everybody who is participating in this. So as Corinne just sort of mentioned in her intro, there's a lot of misconceptions around exclusive use in sectional title schemes. And the types of exclusive use areas that we see very often are things like private gardens, balconies, patios, parking bays, storerooms, garages, but actually any area of the common property can be made subject to exclusive use rights. Now, many owners mistakenly believe that they own their exclusive use area. Some owners think that they have the freedom to use the exclusive use area however they like. They think that they can make alterations to the exclusive use area without needing to get permission. And some even assume that having an EUA gives them a better or bigger say in body corporate decisions. And the reality is that none of these misconceptions are true. And so what we're going to do in this webinar, or I'll do my best to do, is to demystify this concept of exclusive use for you. And we'll dive into what exclusive use areas really are, how they work, and the legalities that come with them, so that you can manage these spaces in your schemes with much more confidence. Can we move to slide 2, please, Corinne? Thank you. So before we dive into EUAs specifically, it's important for you to get a clear picture of the types of property that we find in sectional title schemes. And essentially, there are only 2 types. We have sections and we have common property. So starting with sections, in a residential scheme, a section is usually an apartment or a townhouse. In a commercial scheme, it could be an office. In a retail scheme, it might be a shop or a restaurant. And any other area like a garage, storeroom, other utility spaces might also be a section, but you really need to look at the scheme's specific sectional plan, because it depends on how the developer sort of designated these areas, whether they are actually a section or whether they may be an exclusive use area, or maybe even just an area of unregulated common property. So the sectional plan is a crucial document to determine the legal status of any area within the sectional title scheme. And that should be your first port of call when it comes to looking at, maintenance and repair responsibilities. For example, the first question you ask is, what is the status of that area? Is it a section? Is it part of the common property? If it is part of the common property, is it simply unregulated common property, which means, there's no exclusive use rights over it? Or is it common property subject to exclusive use? And that each of those sort of categories has different maintenance and repair obligations associated with them. Okay, so when it comes to ownership of sections, sorry, Corinne, we can still stay on that previous slide. A section is individually owned by the person whose name is on the title deed of that section at the deeds registry. And as a section owner, you own everything within the boundaries of your section as shown on the sectional plan. Now, moving on to common property. The common property is every single part of the scheme that is not included within the boundaries of a section. So this includes things like the garden areas, swimming pools, hallways, lifts, stairwells, driveways, perimeter fencing, the building's foundation and roof, and even the outer skin of the building. And when it comes to the ownership of the common property, all section owners collectively own the common property in what we call undivided shares. And what this means is that every single section owner has a stake in every single part of the common property. So no individual owner can claim exclusive ownership over a specific portion of the common property. They can't say, I own the pool, you own the driveway. Instead, every section owner has a share of ownership in effectively every brick, every tile, every blade of grass that forms part of the common property. Thanks, Corinne. We can move on to the next slide. So following on from this topic in terms of sections and common property, it's important to know where the boundaries of your section are, especially when it comes to understanding your rights and responsibilities. And according to the Sectional Titles Act, the boundary between 2 sections, or between a section and the common property, is defined by something that we call the median line. And this is effectively the midpoint of the sections dividing floor, wall, or ceiling. And you can see this on the picture in front of you by the dotted lines. So imagine a wall between your section and your neighbor's section. The boundary isn't just on one side of the wall, it's right down the middle. So you and your neighbor each own half of that wall. And the same principle applies to the floors and ceilings that separate sections. The boundary between your section and the common property, like perhaps a hallway or the building's exterior, is the median line. And why does this matter? The reason that I'm telling you this is because understanding these boundaries is very important when it comes to identifying maintenance and repair responsibilities. And it's also important because any area of common property can actually be made subject to exclusive use rights. So it's important to understand what areas in the scheme are actually common property. Can we move on to the next slide, please, Corinne? Okay, so Karina already touched on this in her introduction, but to give you a sort of definition of an exclusive use area, it's a part of the common property in a sectional title scheme. As Kareem mentioned, this doesn't apply to HOAs or share blocks or any other types of community schemes. So it's part of the common property that has been set aside for the exclusive use of a particular section owner, and in some cases it can be a specific group of section owners. And what does that mean? Even though the exclusive use area is technically still part of the common property, it is reserved for the use of one or more specific owners. And this means that while all section owners collectively own the common property, an exclusive use area is different because only the designated owner or owners can actually use that space. They're the only ones entitled to use that space. So what does this look like in practice? Imagine there's a parking bay on the common property. If it's subject to exclusive use rights, then only the owner who has been allocated that space can park there. So even though it's part of the common property, all the other owners are not entitled to use it because it's been reserved for the exclusive use of a particular owner. Similarly, there could be a small garden area that's attached to a ground floor section, and that has been fenced off, and it is only used by the owner of the ground floor section. If it's an exclusive use area, then they've got the rights to that area. Okay, so essentially exclusive use areas give owners the benefit of exclusive use of certain areas without actually individually owning the space, which takes us to the next slide, please, Corinne. So who actually does own an exclusive use area? Even though an exclusive use area is reserved for the use of one or more specific section owners, it's important to understand that no individual owner actually owns the exclusive use area. Because it's part of the common property, it's owned in undivided shares collectively by all the section owners. And the ownership of the EUA remains shared among everyone, just like any other part of the common property. Okay, so if we can move on to the next slide, please, we will look at how exclusive use areas can be created. There are two different ways. We have what we call registered exclusive use areas, and we have rule-based exclusive use areas. So if we move on to the next slide, please, Karine. Let's start with the registered exclusive use areas. These are specific portions of the common property that are officially recognized and recorded at the deeds registry by being placed on the sectional plan. So registered exclusive use areas you will always find on the scheme's sectional plan. These exclusive use areas can be created either by the developer before the body corporate comes into existence, and or by the body corporate later once it has come into existence. And so if a developer wants to create registered exclusive use areas, what they need to do is arrange for those areas of the common property to be surveyed and then marked as exclusive use areas on the sectional plan. The developer will specify what these exclusive use areas can be used for and will allocate them to specific sections, which will be shown in an allocation schedule on the sectional plan. The Registrar of Deeds will then issue a certificate to the developer confirming the real rights to these exclusive use areas, and the developer can then transfer or cede these rights to the owners of specific sections. Now, after the body corporate is established, it can also create new registered exclusive use areas, and this requires the authority of a unanimous resolution of all owners. And again, the new exclusive use areas must be surveyed and shown on the sectional plan, just like those ones that were created by the developer. Once everything is in order, the body corporate can officially transfer these rights to the new exclusive use areas to specific owners. All right, so let's move on to the next slide, please. So let's look at the transfer of registered exclusive use rights. The exclusive use right holder will need to sign a special document called a notarial deed of cession. This document is registered at the deeds registry, and it officially transfers the exclusive use rights to the new owner. Most of the time when a unit is sold and it has registered exclusive use rights attached to it, they will be transferred to the owner at the same time. And this keeps things simple and ensures that the new owner has the same rights to that EUA as the previous owner had. Now, if we can move on to the next slide, please. We look at the second type of exclusive use areas, and these are known as rule-based exclusive use areas. They're established through specific rules, which are created either by the developer or by the body corporate. This happens under Section 10 of the Sectional Title Schemes Management Act, and exclusive use rights can either be granted through the management rules of the scheme or through the conduct rules of the scheme. These rules dictate which areas of common property are for the exclusive use of certain owners. And if exclusive use areas are created through the management rules, we need a unanimous resolution from the body corporate to authorize the creation of those areas. And if they are created through the conduct rules, then a special resolution is required. And because of this lower level of consensus, it's often the conduct rules that are used to create rule-based exclusive use areas. Once we have the required resolution in place, then the rule needs to be submitted to the CSOS for approval before the exclusive use areas actually become legally established, because the rule only comes into force once CSOS has approved it. Now, rule-based exclusive use areas are not shown on the sectional plan. So if you have a scheme and there are no registered exclusive use areas, you don't see anything on the sectional plan, that doesn't mean that there aren't exclusive use areas in the scheme. You do need to go look at the rules as well, see if there are any exclusive use rules in there. These exclusive use areas are shown on a layout plan, which is attached to the rules. This plan needs to be to scale. It needs to show exactly where each exclusive use area is located. It needs to specify the purpose for which each exclusive use area can be used, and a unique number must be allocated to each exclusive use area. The rules will also include an allocation schedule that assigns each exclusive use area to a specific section in the scheme. All right, next slide, please, Corinne. Now, when it comes to transferring rule-based exclusive use areas, this usually happens along with the sale of the unit, and the process is usually quite straightforward. Sorry, I see that I'm actually on the wrong slide here, but it's okay. I'm going to get to that in a sec. So in most cases, a rule-based exclusive use area is allocated to a specific section rather than to a particular named person. And the exclusive use right automatically transfers to the new owner when the section is transferred. So this means that the new owner of the section will automatically inherit the right to use the associated exclusive use area, because the right is tied to the ownership of the section rather than to a particular person. However, in some old schemes, rule-based exclusive use rights were sometimes allocated to specific named individuals. So in the allocation schedule, in the rules, it would say, garden area 1 to Andrew Schaefer. And that's a problem, because then when Andrew sells his unit, we actually need to update the rules to put a new person's name in there. So it's much better in that case, if you do come across any of these types of rules where a named person is allocated the exclusive use rights, it's better to update the rule to say to the owner from time to time of section X, and then that allows for the automatic transfer. All right, so just in terms of the differences between these two types of exclusive use areas, registered exclusive use areas are created through a formal registration process. Rule-based are created through the adoption of scheme rules. Registered exclusive use areas are clearly shown on the sectional plan. Rule-based exclusive use areas are not shown on the sectional plan, but they are reflected on a layout plan, which is attached to the rules. Now, registered exclusive use areas, as Corinne touched on earlier, enjoy a higher level of legal certainty and protection because they are registered real rights and they're considered to be immovable property, whereas the rule-based exclusive use areas are only considered to be personal rights, and so they have a lower level of protection. They can be cancelled or amended a lot easier than the registered EUAs. Now, a registered exclusive use area can be bonded, leased, and have servitude rights registered over them because they are considered immovable property, whereas a rule-based exclusive use area can't be bonded or have servitude rights registered over them. Okay, next slide, please, Corinne. When it comes to the boundaries of an exclusive use area, it'll depend on how the exclusive use area was created. If it's a registered exclusive use area, then the boundaries will be clearly marked on the sectional plan, and this plan will show the exact dimensions and location of the EUA within the scheme. And often the plan will include notes that further clarify exactly where the boundaries are. It might say, this exclusive use area extends to the outer skin of the wall, next to it, or something like that, so then you can know exactly where the boundary is. For rule-based exclusive use areas, the boundaries will be defined in the scheme's rules, and you can have a look at the layout plan to scale, which should show the location and the boundaries of the exclusive use areas. Okay, next slide, please. So now we're going to look at maintenance and repair responsibility for exclusive use areas. So according to Section 31L of the Sectional Title Schemes Management Act, the body corporate is responsible for maintaining and repairing all common property, and this includes exclusive use areas. So this means that unless the scheme has a specific rule which delegates the body corporate's maintenance and repair responsibility in respect of EUAs to the persons who hold those rights, the body corporate must do it. So the default position is the body corporate does it, unless there is a rule which actually makes the owner responsible to arrange and pay for the maintenance and repairs of those areas themselves. In terms of Section 3(1)(c) of the Sectional Title Schemes Management Act, the owner who holds the exclusive use rights, their job is simply to keep that area neat and clean. So the body corporate in the default position handles the repairs and maintenance, but the owners are expected to ensure that their EUA is neat and tidy. Now, can we move on to the next slide to look at who pays for the maintenance and repairs of these areas? So the STSM Act requires the body corporate to charge an additional contribution, which in practice is often called an EUA contribution or an EUA levy, to any owners who have exclusive use rights. And this additional contribution is intended to cover the expenses related to the specific exclusive use area. So it's an owner pays, so it's like a user pays principle, if that makes sense. So in summary, the body corporate arranges for the maintenance and repair of exclusive use areas because they are common property. However, the owner who holds the exclusive use rights is required to pay the body corporate for the costs associated with the exclusive use area. If the body corporate has delegated its maintenance and repair responsibilities for the EUAs directly to the owners, then there's no need for the body corporate to charge those owners an EUA levy because the owners are covering those costs directly themselves. All right, next slide, please, Corinne. Now, assuming the body corporate is responsible for the maintenance and repairs, how are these EUA contributions or levies calculated? So each year, the trustees should estimate the body corporate's anticipated costs for each exclusive use area. And this includes figuring out how much it will actually spend over the course of the year for each particular exclusive use area. The estimated exclusive use area contributions or levies should be included in the body corporate's annual budget. And this ensures that the costs associated with these areas are planned for and accounted for in the financial planning of the scheme. Ideally, exclusive use area levies should be held in a separate ring-fenced account. And this means that the funds collected specifically for EUA maintenance are kept separate from the body corporate's general funds to ensure that they're actually used for their intended purpose. Let's move on to the next slide, please, Corinne, and look at improvements to exclusive use areas. How are these authorized? So Prescribed Management Rule 30G allows the body corporate to authorize improvements or alterations to exclusive use areas by passing an ordinary resolution. The body corporate can set reasonable conditions when granting approval, and if the conditions imposed are not met, then the body corporate has the right to withdraw its consent. It's also important to understand that the proposed improvement or alteration to an exclusive use area must not extend the boundaries or the floor area of the section, because that would amount to a section extension, which requires a much more complicated approval process and a higher level of consensus. Okay, moving on to the next slide, let's look at how an exclusive use area can be used. Its only use is for the designated purpose, which has been specified either on the sectional plan or in the scheme's rules. It can also be shown on the building plan or as is obvious from the exclusive use area's construction and amenities. So for example, if an exclusive use area is designated as a garage, it must be used as a garage for storing a car. Converting it into a flatlet without proper permission or municipal approval is not allowed. Even just using it as a storeroom, if you put so many boxes in your garage that you can't fit your car, that is considered, using it for a different purpose, which would be in breach of the Act. Now, in terms of Section 13(1)(g) of the Sectional Title Schemes Management Act, if an owner wants to use an exclusive use area for a different purpose, they need to get the written consent of all owners. And if they can't get everyone's written consent and they believe that the refusal is unfair, then they can apply to the CSOS within 6 weeks of the refusal and request relief. Now let's look at, in the next slide, some other common problems that pop up with exclusive use areas. The first one is unauthorized section extensions. And this often happens when an exclusive use balcony or patio is enclosed to extend the living area of the section adjacent to it. Now, remember that an exclusive use balcony or patio is common property, and by enclosing it, the owner is essentially extending the boundaries and floor area of their section, which requires a special resolution of the body corporate to authorize, as well as an amending sectional plan of extension to be registered at the deeds registry. And this ultimately results in the PQ of the section being increased, which means that the section owner will ultimately pay higher levies. So when a section owner encloses an exclusive use balcony or patio without getting the right level of authorization and following the section extension procedure, what they've effectively done is illegally appropriated an area of common property, which, as you now know, all owners own, and they're not paying their fair share of levies to the body corporate. So this is a problem. And we'll talk about remedies in a minute. I'm just going to go through the common problems, and then we'll talk about how to solve them. So another issue is unauthorized alterations that don't amount to section extensions. So owners often make alterations and improvements to their exclusive use area without getting the necessary permission from the body corporate. They might build a lapa or built-in braai on their exclusive use garden area. They might install an awning over the exclusive use area patio, and they don't get body corporate approval for this. Okay, these are unauthorized alterations. Another issue is maintenance and repair disputes in respect of exclusive use areas. So I just did an opinion last week for a body corporate where a section had been substantially altered, including works to an exclusive use area balcony, which effectively amounted to an extension of the section, unauthorized. And the owner who did the alterations was long gone. The new owner, wasn't aware that these alterations had been carried out illegally. And the new owner was now demanding that the body corporate repair leaks, which were emanating from part of the building, which was in fact part of the illegal section extension. So the body corporate was arguing that it shouldn't have to take responsibility for fixing part of the building that formed part of the unauthorized alterations. We didn't give permission for you to do this. You messed with common property. This is your problem. And the new owner argued that the leak was coming from common property, from the outer skin of the building, and that it was therefore the body corporate's responsibility. So you can see how unauthorized alterations to exclusive use areas can end up in quite thorny maintenance and repair disputes. Now, another issue is de facto exclusive use areas. And what a de facto exclusive use area is a portion of the common property that is used exclusively by one owner, for example, by fencing off an area of the common property so that no one else can access it, without this area of common property actually being formally designated or registered as an exclusive use area. And this is problematic because the body corporate has no legal basis on which to charge the owner an exclusive use area levy. So even though in reality none of the owners can use that area and they shouldn't be paying for its costs, they are all basically subsidizing this owner in this way. And then lastly, unfair exclusive use area contributions is a problem. As we've discussed, the trustees need to estimate the body corporate's anticipated actual costs associated with each EUA when they calculate the EUA levies. So for example, the amount of money that a body corporate would need to spend on maintaining an EUA parking bay over the course of a year could be drastically lower than what it would need to spend on the maintenance of a garden EUA. But in some schemes, the trustees simply apply a blanket formula. For example, an EUA contribution is charged at 1/3 of the levy of the associated section. And this way of calculating EUA levies can and does lead to exclusive use area levies, which are inaccurate and unfair to certain owners. Okay, so I've told you a lot of problems. Let's look at how you can actually fix these things. So when it comes to unauthorized alterations, whether it's, we can go to the next slide, please. Whether it's an illegal extension of a section or if it's just an alteration that doesn't amount to a section extension, these should either be regularized through gaining the proper approvals, or the owner concerned should be forced to remove the unauthorized alteration. And I've got all the section references and everything here and the processes. I'm not sure how we're doing on time, but I can go through that, afterwards if you need more detail on this. Okay, and then when it comes to maintenance and repair disputes, if it's unclear which party, the owner or the body corporate, is responsible for the maintenance or a repair issue in respect of an exclusive use area, then the first step is to check the scheme's rules to ascertain whether the default position applies, which is body corporate arranges the work and owner pays for it, or whether the maintenance and repair responsibilities have been delegated to the owner directly under the scheme's rules. If there's still a dispute after checking the rules, the parties may then need to get expert intervention, such as an architect or an engineer, and possibly take legal advice once the expert reports have been obtained. And if the dispute continues, then either party can take the matter to CSOS for an order to force the other party to do the work. And to avoid these disputes, the body corporate should ensure that its rules are very clear as to who is responsible for exclusive use area maintenance. And if the rules are not clear, then the body corporate should consider amending their rules to properly regulate this. Next slide, please, Corinne, I think. Yes. Okay, so in terms of the unfair exclusive use area contributions, if an exclusive use area levy seems unfair, then the affected owner can apply to the CSOS for a declaration that the contribution is incorrectly determined or that it's unreasonable, and for an adjustment to a correct amount. And lastly, when it comes to de facto exclusive use areas, the body corporate can pass an exclusive use area rule, formally creating and allocating the de facto exclusive use area as a legal exclusive use area. And if the owner concerned refuses to accept responsibility for the exclusive use area, then the body corporate can apply to the CSOS for an order obliging the owner to accept the exclusive use area obligations. And that is the end of my demystifying exclusive use areas for you. I hope that's been helpful, and happy to answer any questions that you have.
Excellent. Thanks very much, Jennifer. No, that was spot on and very informative and interesting. Maybe some questions, and Corinne, you can come in as well, just to go through some of the themes that are coming up. But maybe the first thing, Jennifer, is, as you gave an example as well, very often unauthorized extensions or improvements are done by previous owners.
Yes.
And the new owner can inherit a problem which either they weren't aware of, or they weren't sort of particularly aware of how they could regularize it.
Yes.
So, is that, you said regularizing is kind of the best practice objective, but there's a process to follow through, which, the trustees need to facilitate in terms of, the updating conduct rules, a special general meeting, perhaps an architect's input to draw the necessary sketches and diagrams and plans as well. So what is your advice about, trying to address issues of the past which are now causing current complications?
Yeah, great question, Andrew. I think, it's such a shame for many owners buying into sectional title schemes. They're not aware of what sort of due diligence they should do prior to buying into the scheme, because sectional titles are often misunderstood. And so new owners do end up buying a property and not realizing that unauthorized alterations have been done by previous owner. And unfortunately, they are the ones who are now left in the hot seat to sort it out. So in terms of regularization, I think, as you said, that is probably the best option if it's possible, because obviously forcing an owner to remove unauthorized extensions is a very extreme measure. So firstly, it depends on the nature of the alteration. If it doesn't amount to a section extension, the section's boundaries of floor area haven't been extended, perhaps it's just a LAPA that's been put up on exclusive use garden area, then the body corporate can approve that by ordinary resolution under Prescribed Management Law 30G, and the body corporate can impose reasonable conditions to ensure that it's used properly and it looks a certain way, whatever the case is. And if the owner breaches that, then the body corporate can withdraw consent. So number one, if it's not a section extension, the owner should propose that the body corporate approve it by ordinary resolution, which shouldn't be too difficult. Now, if it's a section extension, and as I mentioned, this happens a lot with closing balconies, there is a process that needs to be followed. And because obviously now you've appropriated an area of common property and now you've extended your section, that exclusive use area first needs to be cancelled. And it depends on what type of exclusive use area it is as to how that cancellation will take place. If it is a registered exclusive use area, you're going to need to get a special resolution of the body corporate to cancel the exclusive use area, and obviously the sectional plan will need to be updated to remove it from the plan, and then the section extension needs to be authorized firstly by a special resolution of the body corporate, and then through a process of having a surveyor resurvey that section, update the sectional plan, and then the amending sectional plan needs to be submitted to the deeds registry for registration, after which the PQ schedule will all change. And if the PQ of any section is going to be increased by more than 10%, you need bondholders' consent. So there's a whole process that needs to happen there. And sometimes when it comes to section extensions, the body corporate will want that particular owner to actually compensate the body corporate for the fact that this person has appropriated a portion of the common property, because as we've discussed, the common property is owned by everybody. This person has just taken it, so why shouldn't the body corporate be compensated for that? So there's nuances to this, but each particular type of alteration has the potential to be regularized, provided, with something like a section extension, if the bulk on the building, for example, has been exhausted and there's no bulk left, then the council won't approve the building plans to enclose that balcony. And therefore, if that's the case, then there's no point in the body corporate approving it, because it's going to be unauthorized from a council perspective anyway. So yeah, there's a bit of homework to be done in terms of, can this thing be regularized? If so, which type of regularization is it? Are we just needing an ordinary resolution? Do we need a special resolution and the whole process? And also, is it possible from a council and building plans perspective? Yeah, I hope that answers the question.
No, very good. Thanks, Jennifer. And I mean, is it inevitable that the new owner would need to pay costs to get it regularized? Because, is it fair the body corporate would pay, or really does it go down to that owner? It's an unfortunate circumstance of what they're inheriting.
Yes, absolutely. Yeah, it is. I mean, it's not a cost that the body corporate should pick up. So yeah, the unfortunate new owner is going to have to pay those costs. Whether they have some right of recourse against the previous owner is a different question. But unfortunately, often properties are bought what's called foot stewards, sort of as is, and anything that's not, the defect, is quite obvious, even though the new owner doesn't know that it's unauthorized. But there is a sort of onus on potential purchasers to do their due diligence to find out about the property, and it's very difficult, I know, but yeah, it is unfortunately the owner's responsibility to pay for that.
And just talk a little bit about the due diligence, Jennifer. What would be reasonable? How could they reasonably check whether exclusive use areas were correctly either registered or reflected in the conduct rules or management rules?
Yeah, so I mean, first of all, the purchaser is most likely dealing with an estate agent. So, that estate agent should be able to give the purchaser a copy of the sectional plan, a copy of the scheme's rules, and those two documents will tell you whether they are exclusive use areas, in the scheme or not, and whether that particular property or that particular section has an exclusive use area allocated to it, either on the plan or in the rules. And if the purchaser then needs to look at that exclusive use area and say, is what I'm seeing on the plan what I'm seeing in real life? Or is what I'm seeing on the layout plan attached to the rules what I'm seeing in real life when I go to this property? Because if they look very different, then there is most likely some sort of unauthorized alteration that's occurred, because the sectional plan and the layout plan should be reflecting exactly what is there at the moment, in order for everything to be sort of above board. If there's a difference between what's on the plan and what's in the property now, then that's a big red flag, and purchaser should definitely take it up with the estate agent, the managing agent, the seller, and try and figure out what's going on before making an offer.
Good. Jennifer, an interesting question, and this is an example, but it's got broader applications. So in an exclusive use area, let's take a garden, which the section owner is authorized to use as an exclusive use area. They're responsible for the maintenance. Let's say they're trees or the shrubs. Is the body corporate entitled to intervene and to remove tall trees or problematic shrubs, etc., and really take charge if they're not happy with the way that the maintenance being undertaken?
Yeah, so the body corporate has the ultimate responsibility for the common property. And if the body corporate has delegated maintenance responsibilities to, the owners who enjoy the exclusive use rights, the delegation, I would always recommend, be on condition that, the maintenance is done to a standard that the body corporate is happy with. And if the body corporate is not happy, that it can intervene. So, I mean, yes, in terms of the act, the body corporate has got very wide powers in terms of doing all things necessary to, manage the common property and enforce the rules. And if they feel that the owner who has been delegated the maintenance responsibility is not, properly performing those maintenance obligations, then I would say to the body corporate, first thing you do is, notify the owner, give them an opportunity to rectify it. But if they don't, let them know that you will do it and recover the cost from them, because ultimately the body corporate does need to ensure that the common property is properly maintained, including exclusive use areas. And the proviso to Section 31C of the STSMA allows the body corporate to recover the costs associated with an exclusive use area from the person who holds the rights. So that's how I would approach that.
Jennifer, another interesting question that's come through, and just picture the scenario in a particular body corporate. There's ground floor balconies, which are registered exclusive use areas. Those owners are paying an exclusive use charge or contribution to the body corporate, but that charge is not enough to repair leaks into the basement, the parking basement.
Yeah.
So the other owners and other floors are now contributing to maintenance, which they don't particularly have a direct, use of.
Yeah.
What would be your suggested remedy for a situation like that, where the other owners are feeling aggrieved that they are contributing to costs which they don't feel is their responsibility?
Yeah, so I mean, if I was one of those other owners, I would obviously, first of all, notify the body corporate of, the irregularity, because obviously in terms of the STSMA, as I said, it's a user pays principle. So, the persons who are using those balconies should be paying all the costs associated with them, and they should not be being subsidized by the owners who don't have exclusive use rights to those areas. So first of all, notify the body corporate. If the trustees don't do anything about this to correct it, then you can go to the CSOS and apply for an order under, I think it's 39(1)(e), which is, that a contribution is unreasonable or has been incorrectly calculated, and to ask them to make an order for an adjustment to the correct calculation or contribution. So yeah, I would definitely say start with the body corporate first, and if you're not getting anywhere, then go to the CSOS.
Great. And Jennifer, if a particular owner doesn't behave, meaning that they, contravene the conduct rules, either regarding their exclusive use area, for example, they use it for another purpose, or they just breach conduct rules in general, is it an option to cancel the exclusive use area by amending the conduct rules, or would that be frowned upon in terms of, the designation of that area at the beginning?
No, I mean, I think if it's absolutely an option. I would always say, give that particular owner that's in breach opportunities to remedy the situation. You don't want to take away rights unfairly. But if this is a last resort after, following the scheme's usual breach processes, the owner's still persisting in the breach, over a long period of time, then I think it's a fair enough thing to take that exclusive use area away from them. If that's, as long as it's not sort of like a fenced off garden, which they're going to be able to use exclusively anyway in a de facto way. Yeah, I think that is an option.
Thanks. Jennifer, a body corporate that requires more parking,
Yes.
and they would like to, have the opportunity to use some areas of common property for additional parking, and that happens quite often.
Yes.
Would you suggest they rather sort of follow a leasing approach where they get the necessary authority to lease it from a body corporate perspective and generate rental income, or to rather go the exclusive use route and try and, register different exclusive use areas for particular owners to use?
Yeah, that's an interesting question, because, I guess it depends on the goals of the body corporate. So if the body corporate is looking for additional income, perhaps to reduce the levies, then rental may well be a good option. But, the lease agreements will generally be with a particular person. So then each time the section changes hands, they may need to update the lease agreement, unless, I suppose, they put in the lease agreement the owner of the section from time to time. But yeah, if they are more sort of, if the body corporate is more concerned with actually giving a particular section, long-term rights to an area, because exclusive use rights are indefinite, right? Whereas a lease would be generally a short-term lease up to 10 years. You can have long-term leases, but then you need registration at the deeds registry because it's over 10 years. So I would say if it's a long